My name is Ryan Chandrapal. I'm from Armchair Criminal. I welcome you all to this part of the program. This is the final section under section 118 that we are going to consider, and that is based on hearsay evidence by way of confessions. It is important to note that confessions is a huge topic and it deserves a separate section of its own right, and that is why I have decided to create this section. In fact, there will be 6 parts to this section. Very experienced members of the bar and academics have written several articles and books. They include a book written by Mr. Anthony Heaton Armstrong and Mr. David Waljover called Confessions. And there's a superb book written by Professor Michael Zander on pace that comes to my mind. This is a topic that I propose to consider later as a subject of its own. Whilst this section is relatively large, I would regard what I am doing here is merely to touch upon this huge subject and give an introduction. The importance of this topic cannot be overestimated. It's so important. In fact, more people convict themselves of their own mouth than what the prosecution can produce by way of evidence. As humans, what we have not learned to do is to learn how to think and how to act. More importantly, how to talk. So let's start off this topic by considering what is a confession. The definition of a confession is to be found in section 82 of the Police and Criminal Evidence Act, which we call shorthand as PACE, and it reads as follows. Confession includes any statement, wholly or partly, adverse to the person who made it, whether made to a person in authority or not, and whether made in words or otherwise. Remember that we looked at the definition of statement. Equally, we have considered when we looked at common enterprise, the difference between an admission and a confession. Here, it shows a confession comes from the person who's making it, and that has to be adverse to his own interests. And the person who receives the confession need not necessarily be a person in authority. So it could be to a completely a normal civilian. Next, let's pose the question, is the definition of a confession is complete and accurate? Does it reflect everything? Remember the word statement. So how about a person lies or remain silent? Those two situations could form part and parcel of an admission in an implicit manner, or you might think that it can be deduced or inferred that a confession is made either by lying or being silent. Why confessions are important? That is something we should pay some respect to. It is because confessions are regarded as the highest form of a conviction. In other words, would a person, a normal person, would make an admission that is adverse to his or her interest? If it is not the case, then the automatic inference is that person is making that admission, which is a confession, is because it is true. However, there could be circumstances that the person is confessing not because necessarily that it is true. So, let's consider what are the problems and dangers of admitting a confession. There are dangers of admitting a confession. We will look at them as we develop this part of the section. In fact, I think in the next part 2 of this 6-part series, we will consider where some people just happy to admit to things that they haven't done. So some of the problems could be, a confession could be because of a misreporting. The chances are very slim something that is said is misunderstood if it is tape recorded or video recorded, because you can hear it and clarify it. Chances are slim. It could become maybe because of pronunciation, but nonetheless the chances become very slim. But if it is not, it could be that someone misheard and misreporting. Completely innocent, but nonetheless that risk does exist. Then there are people, suspects, defendants, who would have not told the truth to exonerate himself, maybe admitting to things that they haven't done. And that could be as a result of mental health issues. Equally, some people may have been in a compromising situation, cannot tell the truth, because that will be to admit something morally wrong. Like, an example would be a married man being in a compromising situation with another woman. How can he immediately admit that and go home to his wife? So in order to cover up that, there may be situations where people do not tell the truth. Equally, there could be situations where the confession was secured either improperly or under pressure. So for those reasons, not always confessions are absolutely 100% Correct? That is why those who go to police stations in particular should look at and ask for the risk assessment by the custody sergeant to see if there are any mental health issues. Has the person been seen by the healthcare worker? Ask the suspect how is his or her mental state. There may be several underlying factors. The person may not even appreciate that they have a mental health problem because nothing may have been diagnosed. As lawyers, we should be aware, we should be proactive to find out rather than wait until it falls on our lap. Next, let's pose the question, what are the ways in which a confession can be adduced? Of course, we are looking at section 118 of the Criminal Justice Act, and confessions are mentioned there. So therefore, confessions can be adduced as to the exception to the hearsay rule under common law. Then section 76 of Police and Criminal Evidence Act specifically allow confessions to be adduced. And under certain circumstances, it may be possible to seek permission from the court to adduce a confession under section 114 in the interest of justice. Maybe this is a retrial and parts of it needs to be brought out from the previous trial. Remember, even evidence that is given under oath in a separate trial is not, if it is not said here, it remains a hearsay statement. So under those circumstances, it may be possible to adduce under section 114 or under section 119 of the Criminal Justice Act as an inconsistent statement. Classic example is the defendant gives a defense statement setting out, say, alibi, and in the trial, having seen the CCTV recording, he is in the vicinity, suddenly changes his story to take him part in the fight or whatever, public order for that matter, saying this is all in self-defense. The previous statement that was in the defense statement could be adduced as an inconsistent statement. Next, let's ask ourselves the question, if confessions are now governed by section 76 of PACE, what is the need for a common law exception under section 118? When we considered the definition of confession in section 82 of PACE, you would recall that we heard the word statement, and in section 118, yes, statements in that form can be admitted, but equally, even silence or lies could be admitted too. So there is a difference between section 76 PACE and section 118. For example, under common law, a person is expected to deny when challenged with an allegation against that person if that person didn't commit the crime. In particular, where the parties are on equal terms. It may be possible to avoid that inference being drawn if the parties were not on equal terms, like a police officer being there. Therefore, that inference is something that could be adduced to prove or put forward to make the assumption, the inference, that the accused did not make any denial of the allegation when it was made to him or her by another person on equal standing. The authority on this point is a case called Parks. Here, the victim got stabbed. Few days later, she died. Prior to her death, she told her mother basically how it happened and who is responsible. The appellant was confronted by the victim's mother, accusing him of stabbing and asking why he had stabbed her. I got the authority here. And asking for an explanation, basically making the allegation and saying, I'm going to detain you until the arrival of the police. He made no comment except pull a knife out and threaten the mother. And the fact that he did not answer was adduced by the prosecution as evidence of their case. When he was convicted, he appealed, and the court held this case is in fact a Privy Council case from Jamaica, that it was properly adduced because both parties were on equal terms. Not only that, the man went on to pull a knife on the mother. That obviously didn't help him, and neither did he give evidence at trial except to make an unsworn statement from the dock. His appeal was dismissed because the court felt that there was an expectation for him to have denied if he was not responsible for the study. Next, we will consider what is the gateway for the prosecution to adduce a confession. Obviously, by now you would have realized that Section 76 of PACE deals with this particular issue. Let's consider Section 76. It reads, in any proceedings, a confession made by an accused person may be given in evidence against him, insofar as it is relevant to any matter in issue in the proceedings and is not excluded by the court in pursuance of this section. So that clearly gives the prosecution to adduce any confession against the maker of the statement. In other words, he himself. So if he were to implicate himself and another person, the other person cannot be convicted based on that confession by the first defendant. because that confession is only admissible against that defendant, i.e. the first defendant. Secondly, the material should be relevant to any matter in issue in the proceedings. That is why very often we edit things out of a transcript. Not relevant, let's get rid of this, let's get rid of that. Generally, you don't need to go before the learned judge to seek permission. This is done by agreement between the prosecution and the defense. However, if there is material that ought not to go before the jury or the magistrates, yes, we could ask for direction from the learned judge. For example, there could be material quite damning and not directly relevant to the case. The prosecution would love to have that, but the defense can object to it. Classic case is where the police officer in the interview introduces and the defendant then suspects previous bad character and misdemeanors. If the prosecution is unwilling to voluntarily edit it out, then of course you make an application to exclude under section 78 of this, which we will look at a later point. Then next question that one could ask is, in section 82, a statement wholly or partly adverse to the person who made it, what does it mean and how does it affect? Basically, a statement here means an express statement, be it written or oral. But we know from the definition of statements in section 115 of Criminal Justice Act 2003 that gesturing could also include a statement. Therefore, conduct can be regarded as a statement. Equally, we've seen that under certain circumstances, not always, silence could too. Generally, one could argue that is not a statement, but in certain circumstances it's good. We've seen it at how the rule was applied in the case of Parks. There is authority how this kind of behavior could be adduced in evidence. The case called Lee Shu Ling is a case on the point. Again, I have the authority here. This was a murder case. The victim was killed as a result of manual strangulation, and initially the defendant, then the suspect, basically denied being involved. In fact, he tried to say that died of using a skipping rope, and basically he tried to deny it but eventually admitted it. Soon after the admission, the police asked him if he wanted to reenact, basically to show how it happened and explain how this crime took place. He was reminded that he doesn't have to do that, and he volunteered. There was a role playing. The defendant playing the role that he's supposed to have played, and the victim's role being played by a lady, a police officer. The whole thing was video recorded. Again, remember that he was advised he doesn't have to do this. He agreed voluntarily. It was recorded, and the prosecution wanted to adduce that in evidence during the trial. Why not? Why kick in the gift horse's mouth? The defense objected, saying it would have been different if there was a dummy used instead of a real police officer playing the role of the victim, because there could have been not everything properly conducted, but it was allowed to be adduced and he was convicted and he appealed. This is again a Privy Council case from Hong Kong, and the Privy Council said no. He made the confession voluntarily, then he voluntarily agreed to take part, which he could have refused because he was sworn, and the learned judge had the power to exclude if there was any misgivings as to the accuracy or there were serious concerns. It was not. Therefore, the Court of Appeals, the Privy Council said it was properly adduced and the conviction was safe. Consequently, his conviction remained as it is. Next, let's ask ourselves the question, what is the effect of the statement that are exculpatory at the time of the statement was made, but later, in the light of other evidence, becomes a damning statement to the maker, i.e., quote, lying red-handed. Lies can be used to establish basically an admission on the part of the person, because there's an automatic inference a person would lie in order to hide the truth. So therefore, lies could be used to show that it is basically an admission, except that it is not a confession, but it could be inferred by the virtue of the lies that is being made, the whole purpose being to hide the truth. And with regard to exculpatory remarks, in other words, completely a statement that is made in order to deny the allegation which is favorable to him, is not admitted, whereas confessions are. When it is admitted, an exculpatory remark, when it becomes obvious what was said in that exculpatory remark is a lie. Can you remember the example that I gave where a defendant gives a defense statement saying alibi, having seen the CCTV recording, changes the defense to one of self-defense? There, you could see that first try to deny it, and when it fails, comes up with another story. That's what I'm basically talking about. Next question is, in the light of the House of Lords decision in the case of Crown and Nisset, what is the implication of Section 76 and 78? Limitations of Section 76 pace does not apply to Section 78 applications to exclude evidence, because Section 78, unlike Section 76, gives the court, the judge, a discretion to exclude evidence where it will be unjust to do so. The words are, in fact, under Section 78 is slightly different to what I just expressed here. And if there are any dangers of admitting anything, not only confessions, Section 78 could be used. We will look at Section 78 in detail later on. Next, let's ask ourselves the question, if a lie is not an admission, what is the effect of a lie? A lie cannot on its own be the evidence to prove the guilt of the defendant, but it could be indicative of guilt, and the prosecution can utilize that lie to support the evidence for the Crown in order to establish the defendant's guilt, as opposed to merely going to the credibility of the defendant as a witness. There's an authority called Goodway. In fact, the case of Goodway applies a very useful authority called Lucas, which we will look at shortly, and that is where one could ask for what is called a Lucas direction. It is thought that people lie for various reasons. In fact, I touched upon it earlier, and we will consider it now by asking ourselves, what can you do if your client has lied? There are circumstances where you can ask for what is called a Lucas direction, and it is quite important to understand that Lucas direction could be a useful tool that the defense could deploy to salvage a situation. Now, let's take the example that I gave. A married man being with another woman is accused of having committed a crime which coincides with the very time frame that he was with his mistress or girlfriend or whoever. Being unable to bring himself to admit what he has done is the immoral thing. He might very well lie and get caught out that what he described in that lie, what he described in order to raise a defense, is in fact a lie. So in that situation, he can literally say, look, I did lie at the time because I didn't want my wife and children to know what I have been doing. Equally, can you imagine another witness may lie for a different reason, may be to protect a family member. Serious incident takes place, the child comes running home and is arrested, and the mother, who loves the child so dearly, is willing to give false alibi that he has been here all the time. Or the mother takes the blame for the son in order to protect the child. In those circumstances, it is not difficult to imagine a scenario where the lie has been said for a specific reason rather than to hide the responsibility for a crime that he or she never committed in the first place. Equally, there could be situations where the suspect at the time of interview, being interviewed by the police or being spoken to by someone else, is severely suffering from mental health issues, anxiety, depression, learning difficulties, even drug and alcohol. So under those circumstances, there are situations where one could ask for what is called a locus direction. In other words, inviting the judge to explain to the jury that people do lie, not necessarily because that they are guilty of the offense, but for other reasons too. And in order to do that, the court will look at things like, did the person lie deliberately? And was that lie materially relevant to an issue in the case? And the court will look at, was there innocent motive, like we looked at a mother trying to take the blame for the child's wrongdoing. Or sometimes people even lie in order to bolster up a just cause. And we looked at where the person could have been committing an immoral act. Equally, the court will look at, is there independent evidence to establish other than what the witness is saying now. So those things will be considered by the learned judge in giving what is called a locus direction. Next, we will look at a topic that will be of some importance at this stage, but we will develop it on our next part of the program. Can self-assurance be admitted as part of the prosecution case? The short answer is, it could be. That all depends on the circumstance in which the confession came about. If it was a setup, then it may not be. But if it was voluntarily, then it might be. This is something that I will expand in due course in the next part of the program, and we will look at the authority called Ireland and the United Kingdom, where this was discussed. I do not propose to go any further at this stage in developing that part of the program, but that is where we will start off in the next part of the program. Thank you for your valuable time. Hope you enjoyed it. See you soon. God bless.